Call to order this special city council meeting for Friday, December 22nd, 2023 at 1 p.m. I'd ask those who are joining us in the council chambers to please silence your cell phones or put them on vibrate to limit interruptions. And just a reminder to council members and those up at the dais to pull the microphone a little bit closer so those on Teams can hear you. And also for those out in the audience can hear you as well. Moving on to item number 1 on the agenda, that's roll call.
Burlingame.
Here.
Evans. Here. Janser.
Here.
Olson. Here. Pittner.
Here.
Padragula.
Here.
Ross.
Here. Item number 2, Pledge of Allegiance.
Pledge allegiance to the flag of the United States of America
and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Now moving on to item number 3 on the agenda, that is the alcoholic beverage license renewals. What are the wishes of the council?
Move approval.
We have a motion to approve. Is there a second?
Second.
We have a motion and a second. There is some discussion. I do want to bring up that with this list, there are also 4 pending approvals that have gone through the entire process. I think they're just waiting background checks and police chief approval on those. Is that something we want to attach to this as an amendment pending approval?
Yes, motion maker agrees.
Yes.
Second, okay, so we will have those 4 pending approvals added to this motion. Is there any further discussion?
Could you tell us which 4 are pending?
Mayor Ross, council members, the 4 that are pending with PD background checks would be Taco Felice, the South Broadway location, Taco Felice, the Dakota Square, 1685, and Arnie's 2.0. They're all in PD background checks. I will state that they were turned in and put in the system on December 20th, so it's not like staff has had a ton of time, but we've tried our best to get them done. And so as soon as the PD background checks come back and police chief approval with this motion, those would also be approved and not have to come back to council.
Thank you.
And with that, is this also a proper time to talk about the ones, there's a few that are outstanding. I don't know if Chief, if you want to address that, or is that even something we discuss?
Mr. Mayor, members of council, I think it's probably not a bad idea just to publicly state that there are 12 that have not submitted a license. So as of December 31st at midnight, they will not be able to operate. That's 10 North Main, Bootleggers, Comfort Suites, Cookies for You, Gourmet Chef, Hawthorne Suites by Wyndham, Microtel Inn and Suites, Minotoro's Junior Hockey Club, the Putt District, the Station, the Tap Room, and Up Your Axe. So my intent would be to direct my staff to ensure that on midnight, December 31st, they're not operating without a license.
Thank you for that information. Any questions?
Just so the council members know also, there are a few other pending ones in the system. Extended Stay America has not turned in a complete application. There is also Quality Inn Suites has not turned in a complete application because they've not turned in payment. The 6th bar, I believe, is still waiting on some construction, so there's a building issue there. So once the building gets permitted for occupancy, that can come to council. The Trax is also in the system, but they're extended through May of 2024. So that will come probably in May in front of you. And I believe that might be it.
Yes, Carrie.
So, I mean, the motion holder hopefully is just going to stick to the ones that have given us everything that they need, and this is an FYI, right?
Yes, this is
Okay.
all just for your information and also to have it out in the public.
Okay. So I just wanted to clarify that.
And just as a point of clarification for all the businesses, at what time what part of the year did they receive initial notification for the renewal process?
It was middle to late October that they got their initial invoice and letter and application mailed. I think I got 3 or 4 back just saying the address is not good anymore. So I personally emailed or called and sent out all the information again. They've also had at least 2 or 3 financial statements come in. So they have had plenty of notice, and I think I put the deadline the end of November so that they had the chance to get on the council agenda prior to the end of the year.
And it's always been December 31st? Is
Their
the
license is
deadline
always
so that is like tax day, you know when it is.
Exactly. Thank you for that clarification. And so the motion we have on the floor is to approve the completed renewals and then the 4 pending background checks and police chief approvals.
Correct. It would be the 8 that were in your memo plus the 4 that we just discussed that are pending PD approval.
Is there any further discussion? Scott?
Just a question, I guess. So the ones that haven't got to this point yet that Chief Klug just talked about would be out of compliance on New Year's Day. What's the process for them afterwards? Can they apply at that point? Does their liquor license become indefinite, or like what's the process at that, then?
Okay, so it's you have to think of it kind of in 2 separate parts. There's some that hold a retail liquor, beer, and wine license. They're still gonna own that license. They have a year to sell in that period. So as long as they get licensed again, it would just have a different effective date, and that effective date would be the date that it's approved at council. So they can still turn in an application. You are just legally not allowed to sell in the city of Minot without both your city and state. So I would guess that any that maybe haven't realized they still have to do their license would figure that out on December 31st at midnight when the PD lets them know. But they have had ample notice from the city. And plus, I believe the fire department has even been around and done some checks for places that maybe haven't even turned in applications yet.
Anything else? Any further discussion? If not, we have a motion on the floor and a second. Please call the roll.
Pittner?
Yes.
Padragula?
Yes.
Ross?
Yes.
Burlingame?
Yes.
Evans?
Yes.
Janser?
Yes.
Olson?
Motion carries. Moving on to item number 4 on the agenda. That is the hearing KP2 Inc. doing business as the Spot. I've got some little bit of background information here to read off for the council. The next item on the agenda is a hearing on allegations made in a complaint and specification of issues that is attached to today's meeting agenda. The license holder before us, KP2 Inc., doing business as the Spot, and they are the present holder of a retail liquor, beer, and wine license number B18072. The complaint and specification of the issues alleges that on 5 separate occasions in the past year and a half, they have sold alcohol at a location other than the licensed premises to which their city license relates without obtaining a special event permit pursuant to Minot City Ordinance Section 5-40. This item was on Monday's City Council agenda with staff recommendations to suspend KP2's license through the remainder of the year. That recommendation was rejected by the City Council, and instead the Council directed that this hearing be set for today. At today's meeting, the city attorney asked KP2 Inc.'s attorney if they would be amenable to waiving the 5-day notice requirement under our ordinances to allow this hearing to occur today at 1 p.m., and she indicated that on Monday that KP2 Inc. was agreeable to that. What the City Council must determine today is whether these violations occurred, and if so, what action, if any, should be taken against the licensee's city retail alcoholic beverage license. With that, this hearing will proceed as follows. First, the City of Minot will present its case and evidence. The council may ask questions. Then KP2 Inc. and its council can present any evidence it wishes to present to the council. Then city staff will have an opportunity to present any rebuttal evidence if necessary. Then this matter will be submitted to the council for its consideration and decision. Moving on, before we commence with the case at hand, I'd like to entertain a motion as it relates to myself and Alderman Pittner. We are witnesses to two of these violations and have firsthand knowledge. With that, we are arguably have a direct personal interest in the matter before the council of our status of witnesses. Under the state's conflict of interest law, North Dakota Century Code 44-04-22, a person acting in a quasi-judicial capacity for a political subdivision of the state that has direct and substantial personal or pecuniary interest in the matter before that body must disclose that fact to the body, which we are doing now. And we may not participate in or vote on the matter without consent of the majority of the rest of the body. It is my understanding that there were prior representations by the licensee's attorney to the city attorneys that they did not object to participating and voting in this matter. For the record, is that still true?
Thank you, Mayor, and yes, that's still true.
With that, I will entertain a motion regarding whether myself and Alderman Pittner should be allowed to participate and vote in this matter.
Mr. Mayor,
Mark.
I'll make that motion.
I'll second.
We have a motion and a second. Discussion.
And just a point of clarification, is the motion that you do not object
Correct.
to it? Okay.
Is there any discussion? If not, please call the roll.
Janser,
Yes.
Olson,
Yes.
Uh,
Padragula,
Yes.
Burlingame,
Yes.
Evans.
No.
Motion passes.
With that, we will submit this to our city attorney, Stephanie Stahlheim, to begin the city's case in chief. Also joining us via Teams is Katie Schmidt with Onstead Twitchell, who is the city's conflict counsel. Ms. Stahlheim is also a witness to one of the alleged violations, so if we have any questions regarding a legal analysis where we need an attorney to explain and comment on the evidence provided, Ms. Schmidt will step in to act as city counsel, as the city's counsel, to avoid any confusion regarding Ms. Stahlheim's as a witness and attorney for the city council. At that, I will turn this over to our city attorney.
Thank you, Mayor. Ms. Schmidt, are you available on Teams? Could you just give us a audible notification that you're available so we can ensure that Teams is working and you can hear us?
Yes, I'm here. Can you hear me?
Thank you.
Perfect.
Okay, so good evening, council. As mentioned, I'm a witness to one of these allegations, so my role here is going to be different than what it typically is because I can't advocate at a hearing where I'm also a witness. We do have two city attorneys in our office, but since they're the direct supervisor, it would also be a conflict of interest for them to conduct some kind of direct examination of their supervisor, which is why we're bringing in Ms. Schmidt in this specific capacity for this hearing here today. I'm just going to briefly comment on one item before Chief Klug presents the city's case, and that's what you have in these packets. So what we did before this hearing is the city clerk, Michaela McWilliams, prepared these paper copies of the agenda here today. And she's added some tabs indicating where the notice of hearing is at, where the complaint of specifications is at, the violations. These are all attached to the meeting agenda. Some of the documents that are attached to this item are very lengthy, so some of those are not included in this paper packet. But if that's something that you want us to display, I do have my computer plugged in, and if you specify the document that's listed under paragraph 4, I can pull that up and we can display that on the screen for yourselves and everyone that's here today. A couple of other items that are here. The city's alcoholic beverage ordinances are found in Chapter 5 of the Minot City Ordinances. Minot City Ordinance Section 5-32 is what relates to a possible suspension or revocation of a license. And also relevant is Minot City Ordinance Section 5-40, which requires the special event permit if a license holder is going to relocate their premises. At this time, I'm going to turn the matter over to Chief Klug. He's going to review the complaint and specifications with you and answer any questions that you may have. And he'll also be available after the license holder comments on these allegations as well, if you have any questions at that point. And again, if you're looking for a legal explanation or a comment on any of that evidence that's presented to you, that's going to need to come from Ms. Schmidt.
She's on the line.
She's on the line, yep.
Good afternoon, Mayor and council members. As you know, the police department is responsible for the enforcement of the alcohol ordinances under Chapter 5 of Minot City Ordinances. And information came to our attention that warranted an investigation of the spot, which is located at 6 2nd Street Northeast in Minot. We became aware of potential violations of Chapter 5, Section 40, which prohibits a licensee from allowing the sale and consumption of alcoholic beverages off the premises to which their license specifically relates. In each of the following events, we believe the licensee violated Chapter 5-40 for sale and consumption of alcohol without a special event permit while operating on the second floor of their business, also known as the venue at the spot, which is not part of their licensed premises. We were able to identify witnesses to the following violations. On October 29th, 2022, alcohol was sold and consumed, and that event was attended by approximately 25 adults. On December 10th, 2022, alcohol was sold and consumed, and that event was attended by about 25 to 30 adults. On January 7th, 2023, alcohol was sold and consumed, and that event was attended by about 100 adults and children. On January 26th, 2023, alcohol was sold and consumed, and that event was attended by approximately 125 adults. And on December 2nd, 2023, alcohol was sold and consumed, and that event was attended by about 200 adults. I submit the 5 violations of Chapter 5-40 to you for consideration of a penalty as described under Section 5-32, which states the City Council shall have the power to suspend or revoke any license issued under the authority of the chapter for any of the following reasons. In this case, subsection 1 states, the licensee violates the laws of this state or any of the provisions of this chapter. Based on that information, I would stand for any questions clarifying the facts as I stated them.
Are there any questions for Chief? Carrie?
So my question is in regards to the first few violations that occurred in 2022. How come it is December 17th, 2023, and we're just dealing with these?
Mr. Mayor, Councilmember Evans, so this all came to light on about June 7th, when a special event permit, sometime in the weeks prior to June 7th, we received a special event permit from Sherry at the spot. That kind of brought light to the fact that there was an event to be hosted, and as you've heard, several staff members have been at events there, so we started asking questions about why are we getting an event permit now and what had happened in the past.
Got it.
So from that point, the next violation we heard of was the event on December 2nd, and that was the event that I had 2 members of my department go and, I guess, investigate that incident, and that's how we got to today without any prior incidents being enforced.
So would the normal be, like, let's say you knew about the 10/28/22 violation before June, it would have been dealt with in a timely manner back then?
Then we would deal with it as an investigation at that time.
Okay, I just need one clarification. Thank you, Chief Klug.
Any other? Steve?
Yeah, I had 2 questions. This may be for the chief or our outside counsel. The first is, since the applicant is being charged, or the holder is being charged essentially with serving liquor off the premises, where and how do we define premises? I mean, this is still the same building, it's the same physical address.
Here, it's in the application.
Could you clarify how premises is defined?
Yes, I can. Mr. Mayor, Alderman Padragula, so when they apply for a license, they have to indicate on a diagram what their premises is. In the case of the spot, their diagram is the first floor and does not include the second floor. So that would define their premises.
So it's self-defined.
It's self-defined, and it's done at the time of licensee.
So if they had had another picture, another schematic with the second floor on it, that would have qualified if that would pass inspection.
That's correct.
Ask
Well,
the city
you could
attorney
wanna
to
have-
pull up the diagram, just so we all can see that.
But you also want to clarify, Chief, on, there's a reason also with the certificate of occupancy.
Right. So, Mr. Mayor, Alderman Pajagula, so when the special event permit did come to us, we learned that there were several violations of fire and building code. So, based on the safety issues, I would not issue a permit for an area that didn't have a certificate of occupancy or meet code. So that was the reason that I denied that permit. And ultimately, that would be the reason that they could not premise that as part of their liquor establishment, because they don't have a certificate of occupancy to even occupy it.
I understand that we have a committee that will be starting to look at the liquor ordinances this coming year, and I guess I would respectfully recommend they look at that and clarify it, because, to me, premises sounds like an address, and if it's what you draw, I think that should be made more clear. The other question I have relates to that, and I'm wondering if this might be some sort of a loophole. In Section 5-35 of the ordinance, it talks about an individual or a license holder having the authority to periodically expand or contract the licensed premises at a particular location as the occasion demands, such as when, for example, a motel licensee dispenses alcoholic beverages at a public assembly room within the motel during a convention or other special activity, when otherwise such room is not ordinarily used for the service or consumption of alcohol. Could the petitioner kind of seize on that and say that gives them the discretion to temporarily expand, which is what seems like what they did here?
Mr. Mayor, Alderman Pajagula, in my opinion, no. So hotel licenses are a little different in their makeup because they occupy a space within their building that is for hosting the event. So their space is self-defined, and that the permit as it's defined under city ordinance allows for those changes.
But they use motels just as an example. It doesn't limit the expansion to the motel as I read it.
Any other expansion of an area would require a special event permit. So there are cases where, even in the case of the spot, where they expand to outside, if that's outside their premises, they have to file a special event permit. And that's covered also under state law. So I can't explain exactly why this was put in or what the intent of it is. Maybe legal counsel could, but I cannot.
Again, I have no objection to that, but I think it should be made more clear because there's several other examples. For instance, a golf course can have the premises and also 2 portable golf carts, apparently, or beverage carts. And I think there are several other examples like that. So, if I were just a layperson reading this, I guess I'm not sure I'd be terribly sure as to what a premises is. And, I could see this, misinterpreting it, see this as allowing me to make temporary adjustments as long as I don't serve it outside or at a different address. I think that should be clarified for the benefit of the public and a potential licensee.
Could we get special counsel to comment on that, please? Whether or not
Sure.
that is
Yep.
an exception that would fall under this?
Sure. I'm reading it maybe differently than the alderman is. This to me seems like a situation where in the spot's circumstances, they were maybe having some sort of activity event on the first floor, and they needed to expand maybe into other rooms on the first floor just in order to
Are you with us, Katie? I think we lost her.
Oh, I'm still here. Can you hear
Okay.
me?
Oh,
Now we can.
Okay. Did you hear anything I said, or I can start over?
Just start over.
Okay. So this to me seems like the sort of circumstances where it's kind of a one-off sort of happenstance where you have an event scheduled within your licensed premises and you may just need to expand it within that same locale because you had more people attend than you initially anticipated. So it's just kind of, it's an anomaly. It's something that's happening. It's just this quick little expansion because you needed the space at the time. It still is within your occupancy limits, but you just need to slightly expand it. In comparison to this location here, this is an entirely separate level of the building, and the violations came on very specific instances where events were specifically scheduled in that space on that date, on that time. And so to me, it's not really an exception that's applicable here because it seems to be more of a one-off happenstance circumstance where these violations were more intended to be in that space that was not under a special event permit at the time.
I can see what you're saying, counsel, but I guess I don't want to, I think it's for the layperson, that's not something they should have to be in. They shouldn't have to hire a lawyer to make it explicit. So when we revise this, I'd like that to be made more clear. I don't want to spend time in court where someone else can come up with another argument. I mean, I accept your argument, it's plausible, but I think someone could equally make the opposite argument, and I don't want to be in that position as a city spending time and money on lawyers and in litigation. So I just ask it to be clarified when it's revised.
And I also think, too, that one of the outstanding contributions or contributors to this was they didn't have a certificate of occupancy to have anybody up on that second floor. It wasn't safe for the public to be on that floor. So,
Yeah, I
okay,
understand that,
okay,
thank you.
Okay. Mark?
Mr. Mayor, could I ask a question of the chief? In the course of these events, and you indicated that in at least one case, your department investigated what had happened. Was direct contact made with the owner in those instances, and was the owner, was it explained to the owner that there was a problem with using the second floor and why?
Mr. Mayor, Alderman Janser, in the event on December 2nd, Sherry was present. They made contact with her. She understood why she couldn't serve alcohol, and she understood why that location had to be shut down. So we didn't get any pushback in those instances, and she complied with the directives we gave.
Thank you.
Paul?
Just maybe a clarifying question. Was one of the exhibits in our, and Steph, if you want to pull it up, it would be page 27, and I think it's the Spot PDF. Letter from Attorney Kelly Hendershot. And I'll just quote one line from here when I find it. The final paragraph, just for clarification, this letter only concerns the necessary requirements for your client to ultimately obtain a permit and a certificate of occupancy for the area of the structure identified as the Spot. This letter does not relate to any other areas of the structure or any potential licensing requirements. And then if you go down to page number 36, this review does not address any planned future occupancy of use for the basement or second level. If these spaces are developed, the code requirements would have to be reviewed, and renovated spaces would be required to meet code based on the occupancy intended. Was this the first time that this was communicated to the applicant, October 3rd, 2016? Are you aware?
Mr. Mayor, Alderman Pittner, I'm not 100% because this, I believe this letter was issued due to the code requirements, which I wasn't part of. So I can't answer that.
Go ahead, Paul.
But is it safe to assume that the applicant's been aware that they don't have a C of O for the upstairs or the basement since October 3rd, 2016? At least?
I think based on the information in front of us, yes.
Okay, thank you.
Do we want to get, is Luke, are you available to provide some clarification on that? Can you step up?
Are there any specific questions that I can answer about the certificate of occupancy that is lacking on the second?
Did you need some clarification on that, Paul, on the letter?
Well, I guess maybe, Luke, what is your history, I guess, with ever trying to obtain, had there been permits pulled on the property? I know that's been an issue in the past. Just give me your version.
Mayor Ross, Alderman Pittner, I was involved back in 2016 with this particular architectural code review that is up on the screen now. I did highlight that on the bottom there for the sake of the scan into the documentation. And then I originally found out about the events being held on second floor in June, I believe, of this year, at which time I was contacted by Joe Stenbold, her contractor, the contractor for the spot. I did hold a meeting with Joe Stenbold and Sherry at my office and kind of went over the list of code violations that were assumed, because I had not been there yet at the time, knowing that there was only one way to get out of that second floor that was legal with the building code. I met them on site at the spot, did a walkthrough. I ended up providing a follow-up email, which listed the violations that were visible to me at the time, with an explanation of how to achieve compliance, essentially, in that list, which is also in your documentation. So that was the first time that I knew that I told her that there wasn't supposed to be anything on the second floor. We've had multiple follow-ups since then.
Paul?
I guess maybe follow-up. Have permits been pulled for all the work being done prior to work starting?
Mayor Ross, Alderman Pittner, no. We did receive an application for work that has already been completed, which I'm not able to issue a permit with the documentation that was provided. We did have a sit-down on the 15th of this month with Sherry and her legal counsel, where it was explained to her how to proceed now that work has been completed with no inspections or the benefit of a building permit.
Paul?
Luke, what are your credentials? Like, what's your role? You're the building inspector, right?
I am the building official for the city, so all the inspectors are out there under my authority.
Why do we have building codes?
Building codes are to protect life and safety, especially when it comes to buildings that are publicly occupied. So residential building codes are handled a little different, and it's an entirely different book, because that is your own personal property. You live there, you're familiar with the way to get out. Commercial buildings are different. The power goes out, no one really knows how to get out without signs. So the code is a little bit more stringent, especially where we assemble a whole lot of people in one area. And that's the issue here, is that we only had one way out for, I think the design occupant load ended up being 265 people. So that's half. You're supposed to calculate half out of each exit because 2 would be required from that floor. So trying to push 265 people out one door is why the code wants you to have 2.
Okay, thank you.
Are there any other questions of Luke? If not, thank you, Luke. Thank you. I believe, Steph, at this time, we offer it up to
Yeah, are there any further questions for city staff about the complaint?
No, but if we can still ask questions after. Okay.
Yep.
Yeah, after KP2
Want to make sure.
proceeds, then we have another opportunity to, yep, absolutely. So at this time, I think we turn it over to Ms. Hoffer and KP2 Inc.
Thank you, Mr. Mayor. Mayor, City Council members, thank you for the opportunity to speak with you today. Of course, we're here to discuss this complaint. The Spot has agreed with the city. We made that agreement during our sit-down last week that they would admit to these violations for the purposes of this administrative proceeding and for the purposes of that we can move forward on this matter. So from my perspective, we're here really to talk about penalties for the violations of the city ordinances. So this is the first time that the Spot has appeared before the City Council for a liquor violation in 7 years of operation. The Spot is rarely visited by law enforcement. It doesn't have fights on its premises. There's not been reports of disorderly patrons, and it diligently prevents the consumption of alcohol by minors. This is all stemming from, the investigation appears to be stemming from an event on December 2nd of 2023, where the Spot held an upstairs event in the building upon the belief that it was authorized to do so after the installation of the new fire escape and completion of the work requested by the city building official on the second floor. So the second floor has remained largely unchanged since it was first purchased, with the exception of some paint and some flooring. Ms. McLaughlin believed that when the new fire escape was installed, that the building code certificate of occupancy issues had been resolved. She later learned that the contractor that was hired to install the fire escape and to do that work had not applied for the permit prior to. She had made a contracted with a company who she presumed had pulled the permits to do the work, who had not done so. And that is what you've seen in the records of the application after the fact. It was after the Spot called and said, "Where's the permit that they had determined to do that." So Chief Klug testified, and if you had seen the body cam, you can see that Ms. McLaughlin in the Spot was cooperative with law enforcement and immediately closed. It's going to continue to work with the city to resolve the inspection of that fire escape, completion of the code study, and issuance of the certificate of occupancy. As a result of that sit-down that Mr. Tillman talked about, we do have an idea of the things that we do need to do, and so we're waiting on some of the professionals that the Spot has hired to resolve those issues. As Council Member Pajagrula already discussed in 5-35, there is this exception for temporarily expanding the position at the event in December of this year. I believe there's information on the body cams from the officers that do show that this party had stuff going downstairs and that they came upstairs to eat and then were returning back down to the main floor of the Spot. So we think that falls within the exception of 535 as well. As for penalties, we believe that the stipulated agreement that was provided with by the city attorney at Monday's meeting, and it's in the record here today too, would be appropriate. So the Spot has been closed as agreed with the city staff, so that in that stipulation, so they have been closed since 11 p.m. on Monday evening and plans to be closed through the end of the year. Ms. McLaughlin has taken a step back from the business over the past year to care for her father, who has Alzheimer's and was recently placed on hospice. In an effort to try to make sure these sorts of issues don't happen again, there's plans to hire a new manager who will handle the special event permits and work with the building officials to get that information as needed to get the certificate of occupancy. The Spot is cognizant of the fact that by admitting 5 violations, the Minot City Ordinance does recommend a revocation of license. But we believe the council has the authority to deviate from that recommendation. We believe revocation is too harsh for business that's only come before the city council for liquor violations one time in 7 years. The primary goal of liquor license regulations should be encouraging compliance rather than punishment. It's a balance between deterrence and fairness. The high penalty of revocation would have a negative economic repercussions for both the spot and the city of Minot and would be too punitive. It would cause the spot to close, and it would have an economic impact of a loss of 9 jobs within the city. The spot is Minot's only billiard hall, hosting numerous patrons during the year, especially when pool league and dart league is going on. It hosts several large pool and dart tournaments. It brings people into Minot for its events. It held the firefighters ball in conjunction with Visit Minot and other Minot businesses during the firefighter state convention. A VFW fundraiser raised over $15,000 for suicide prevention. The Pink Ladies Dart Tournament raised money for cancer patients. There was a Companions for Children's fundraiser. The Hunger Games, which is a fundraiser for local animal rescues, also occurred at the spot. Milo Jones Pool Tournament raised funds for a local scholarship fund. Spot also highlights local songwriters who perform original works, has regional and local bands in the summer, hosts paint and sip events, and numerous class reunions. The Spot is a business that supports and encourages people to participate in Minot's downtown through the Downtown Association and participates in the DBPA pub crawls, the DBPA event Straight Up and Toasted, the Food and Fun Festival, Downtown Food Truck Event, Tacos and Tequila Food Truck Event. Just recently participated or held the Santa and his reindeer in conjunction with the tree lighting ceremony the day after Thanksgiving, where it was free to all ages to see Santa, see the reindeer, have hot cocoa, hay rides, and before and after the tree lighting, it participated in a candy cane scavenger hunt in conjunction with the CP rail train. And it just generally promotes downtown traffic within Minot. Another thing I think we should point out that it's diligent in trying to prevent consumption of alcohol by minors. There's never been an assertion that they have allowed that. The Spot's employees take the responsible beverage server training, and it scans all IDs when you a patron enter the bar. So we would ask that the council accept the stipulated agreement that has been presented by the city attorney. Being closed for this length of time provides punishment for the violations. It's both economic and by reputation, and it's a deterrent for future violations. This strikes a balance between enforcement, support for businesses, and promoting responsible practices within Minot's ordinances. The Spot does apologize and will be compliant with all liquor license requirements in the future. So, happy to take some questions.
Are there any questions? Paul?
Maybe just a question for our staff. Just understanding process here. They state that the spot's been closed since Monday at midnight, but that is not a requirement, correct? Due to the action we took on Monday, we denied the application, so that is on their own accord? Okay, just want to be clear.
Correct, that's how I see it.
Okay.
Steve?
Yes, just a question. Does the business premise, I don't know what to call it, premise, currently have a certificate of occupancy?
The main floor has a certificate of occupancy.
But not the second floor.
Not the second floor. We're working with the, we're waiting on information from the professionals to get Mr. Tillema the information that he needs.
Okay, thank you.
Any other comments? Questions? Thank you.
Thank you. Thank you very much for your time.
Yep. At this time, do we have any rebuttal? Chief?
Mr. Mayor, members of council, I guess what I would point out is maybe intent. And I understand that we're bringing 5 violations to you, but from the time we shut them down on December 2nd and made them vacate that location, we also shut down, prior to the event happening, an event on December 5th where a military Christmas party was supposed to take place in the evening. December 7th, the DVCC fundraiser was supposed to take place on that floor. We have a special event permit that was submitted for, I think, might be this coming weekend. I can't remember exactly off the top of my head, but that was denied. So I think as we look at this as staff, I have a hard time believing there's intent to stop the behavior when there was no actions on the owner's part to stop that behavior. And we had to reach out and shut those things down and make contact with businesses. I know there was at least one other one, I can't think of what it was, but, and all of that is time consuming for staff to have to chase down events that really aren't our problem, other than to protect safety of our citizens.
Any questions? Carrie?
So Chief Klug, you've seen the stipulated settlement. What, if that is not the, what you would recommend, what would you recommend?
Mr. Mayor, Alderwoman Evans, so the 12 days, just the closure through the end of the year, the reason that I submitted that was because that is all that was left of her license. Outside of that, and what's in front of us, I guess today would be, yeah, that's what's still being proposed, but that doesn't bring into account what happens with next year's license, and that's part two of what we're dealing with here. So, in my opinion, the longest I could ask for a suspension was through the end of her license, because at the time she had not submitted a new license. That was just submitted and, well, approved today for your consideration.
Right, so we're doing 2023's license, but, and then and the next agenda item is 2024's. So, okay, thank you, that cleared things up for me, as far as 2023 goes.
I just want to clarify for Chief Klug, because I did pull it up on my computer, the last event permit that was submitted by Ms. McLaughlin for the spot second floor would have been for the 15th through the 17th
This month?
of December, correct. It says that there was Christmas parties.
Steve?
Yeah, I had a question. Have they technically been found in violation prior to this? I'm looking on section 5-32, where it outlines the penalties. The first one being a letter of warning, then business closed for 3 days, then 7 days, then 30 days, and the final one being revocation. Have any of those penalties been imposed prior to this?
No.
No.
No, they have not.
The first formal,
Mr. Mayor, Alderman Pajagula, as I explained earlier, this is the first, when we responded on December 2nd, that is the first one that occurred that we were aware of, that we could investigate after we had informed her she could not do events on that floor.
and yet you kept applying.
She didn't apply, she just kept having events.
But I thought the clerk.
She only applied for the one, so I think Chief Klug we had found out about December, was it December 2nd or 3rd?
And I would, Mr. Mayor, Alderman, I guess council members, we didn't put a lot of effort into going and finding every violation we could. We had 5 we identified very quickly, and in my opinion, we didn't have to dig any more. If the council wanted us to, we could probably come up with however many to go back the 2 years that ordinance allows. But in my opinion, there's 5 violations there. We wanted to present those to council because we want the activity to stop and we want the members of our community to be safe. Right. So that's what we brought to you today, but I think we could show many more.
And to follow up on Carrie's question, you recommended suspension of the license for as long as it lasted this year, and we have a separate agenda item coming up. We'll talk about for the year of 2024, and you'll be offering recommendations at that point.
Mr. Mayor and council members, I think I'd leave it up to you at that point. I offered the original deal because that was the best I could do under what I
Right.
had. And we wanted to bring something to the council that
Right.
we had
I
tried to
appreciate
do
that.
without reaching this level. So once that was rejected, I think at that point, to me, it was clear that the council wanted to take action on this item, and our recommendation was rejected at that point. So I would still stand behind, yeah, the suspension should take place through the end of this year, but as far as next year, I would just wait until we get to that item. But-
Okay, thank you. And I'll be asking the outside counsel her opinion at that point.
thank
too.
Hang on, Paul?
No questions for Chief.
Okay.
But just wanted to speak to one of the violations. I think the oldest one on there is I am a witness in, and that simply came to light because we had a meeting, I believe it was December 6th of this year, right after kind of some of this came to light and came up in conversation, and hey, I was up there. I mean, and that's how I became a witness. That's how that one came to light. It wasn't really any digging. It was just, if you want to say right place or wrong place, depending on which side of the issue you're on, that I happen to be here and be a witness and have attended an event there. So, again, I have to agree with Chief Klug that these are the surface level ones. This is the lowest hanging fruit. I'm sure if we really did some digging, we'd find a few more at least.
Just a,
A
go ahead,
question
Lisa.
a question for Alderman Pittner. When you were there, did it seem apparent that you were going upstairs because there was lack of room on the first floor, or was it intended to be on the second floor?
Mayor, Alderman Olson, no, it was advertised to be on the second floor.
And in response, in kind of following up with Councilman Pittner's, I mean, mine was, to attend a chamber business after hours event, you assume everything is on the up and up and everything is safe and you've got all that, you just make that assumption. Then when we were part of that meeting, realizing that there wasn't a certificate of occupancy, then all of a sudden you go, oh, I was there for this event. And then, so that's how I think those kind of came into being was during that process, so.
May I add something? So one of the first things that I became aware of at the beginning of this process was actually in mid-November. As we went through the denial of the permit process and we became aware of some of these issues that we were working through, the city attorney came to my office, or brought to my attention that she had come across a posting of an event on social media. It was a holiday boutique mixer to be scheduled on Sunday, December 3rd. And the description states, Christmas shop all the above local boutiques upstairs at the spot. $5 at the door, kids welcome and free to attend. Cash bar and first 20 people receive door prizes. Enter through the side door by the gas station, Sunday, December 3rd, 2 to 5 p.m. So we became aware of that. I had a conversation with the mayor. He talked to the organizers. That event eventually got moved and relocated somewhere else. But then we still had the violation with the Hess Christmas party, which was the December 2nd event. So my concern is that we, as staff and as the city, were proactive in having conversations with the property owner, moving that so that violation didn't occur, and then a subsequent event occurred, which is the violation that we've also documented here this evening. So I just want to make sure the council was aware of that circumstance as well.
Steph, did you have a follow-up?
I was just going to concur with Alderman Pittner and the mayor. When I was invited to the spot, it was through my husband, and it was a work Christmas party. So it wasn't under any circumstance where I was going to check into the certificate of occupancy before going there. It was just an invitation, and we went. So, and it was held on the second floor. That was how it was advertised and relayed to me, that the event was on the second floor.
Okay. At this time, I guess we move into the, if there's nothing else. Deb?
Thank you for allowing me just to make one further comment based on what Chief Klug said. These events that were planned, that Chief Klug was just talking about, or special event permits that were denied, once this occurred on December 2nd, the spot did contact all of those parties and cancel them. I'm unaware of what the city was doing on their end, but the spot had applied for a special permit only in the event that the certificate of occupancy had been approved, which it was not, but she canceled all of those events as well on the spots end. I just wanted you to be aware of that. Thank you.
Thank you.
Any other questions? Okay, thank you.
Okay, at this time, I will entertain a motion. Paul?
Mr. Mayor, I would move that we direct staff to revoke the license for the spot, DBA, or KP2 Incorporated, DBA The Spot.
We have a motion. Is there a second?
This is the 2023 license.
Correct.
Okay.
Second.
We have a motion and a second for, go ahead, Paul.
I guess the reason that I'm bringing it up is because this is what's an ordinance. We have 5 violations, we revoke the license. This is a case of a license holder knowingly and repeatedly ignoring code requirements, knowingly putting customers and citizens of Minot in potentially life-threatening situations. Like the building inspector stated, we have building codes for a reason. They're to protect citizens, to protect life. If we move forward knowing that there's violations or behavior, repeated behavior of violating these codes, putting people in harm's way, there's a level of responsibility, I believe, on the city and on staff. And I want to commend staff for the work that they've put into this. I think they've done a great job in trying to do their jobs and take it serious and protect citizens in life. I think we need to take this seriously, not only for the reasons I just stated, but we're also setting a precedent. We're talking about a 12-day, 14-day penalty for a 5th violation when that doesn't even, that barely goes over the 3rd violation, falls between the 3rd and 4th violation levy. And I'll be completely honest, I don't even know if I'm going to vote for this. But I think it's something that we have to discuss. I think we have to discuss it at this level. I think we have to discuss it as being a revocable offense because it's serious. And I agree with the applicant. They do a lot of good work. They're a great business to have in our downtown. They're a great business to have in our community. I think they do a lot of good work. But that does not absolve you of putting people in harm's way, knowingly and repeatedly. From the documentation within this memo, it dates back to 2016. There's been habitual behavior in ignoring pulling licenses, whether it was demo licenses for renovating the property, having adequate inspections, adequate fire code, adequate safety items in place. So I don't accept, I didn't know any better, or there was a miscommunication. There's a responsibility on the business owner, I believe. So again, I just want to have, I'm providing that motion, honestly, to have this discussion, because I think it is a revocable offense. Whether or not this council wants to go that route, I guess we'll find out.
Carrie?
So Paul, there's really not a difference between your motion and the stipulated settlement. Both mean till December 31st, they can't serve alcohol.
Paul?
If I can respond, and staff can correct me if I'm wrong, if a license is revoked, the license holder is not able to hold a license within the city of Minot for 5 years.
Oh, okay. Is that,
That is section 5-34.
oh, there it is. Yep, thank you. Okay.
So if I just clarify,
Go ahead.
I believe that what was offered was a suspension through the end of the year. That was the previous staff recommendation, was a suspension. A revocation of a license carries a little bit more weight.
Got it, yeah.
So again, I just want to clarify. I don't know if I'll vote for
Yeah.
that. I don't know if I'll support that action, but I think our ordinance provides us direction for a reason. This was a document that was put in place because we hold license holders of liquor establishments to a higher standard when it comes to safety, and commercial properties to a higher standard when it comes to safety. So I believe this is a discussion. Whatever the outcome is will be determined, but I believe this is a discussion that has to happen.
I have more. So, not for you, Paul, just generally. I'm not going to support, I think, the motion. I'm leaning more towards the stipulated settlement, only because of, I think, the circumstances. This is the first time this establishment has been in front of us. We have we still have the 2024 license to, determine, but, even if a license is given, right, we will have power over that license and future violations, and certainly, coming before us a second time with a violation, would be within the parameters of the 24 months we have, right, for the 5 violations. And if the 2024 license is issued, it could be revoked, right? So I think I'd feel differently if this was a repeated offender, and if there was problems with this establishment. I think closing down through New Year's Eve is sending a message to they're losing money. The biggest night of the year, which is New Year's Eve, and from the other events they've lost. So I'm not going to support the motion to revoke.
Lisa, did you have some?
Yes.
I'm sorry, I thought you had
no,
your hand
yes,
up earlier.
Yes, thank you. So I've been on the council long enough to go back to 2016 when some of the documentation that was provided to us, I saw firsthand. And my recollection from that time and hearing what's happening now, zoning codes, safety codes have not been a high priority for this business owner. We had numerous meetings and numerous testimonies related to fire suppression systems. And as a council at that time, we're asked to waive some of that on the side of business, on the side of pool tournaments that had been scheduled, and money would be lost if we weren't somehow lenient. And it was difficult at that time to make decisions, and I think that that's what we're being asked to do again, to put safety for our citizens aside. And I have a hard time with that, and it was ironic and sad at the time that we were dealing with all of this in 2016, there was a tragic fire in Los Angeles, and I remember hearing it on the news, and it was almost an identical type of building. It was a cinder block building, and there were a number of people in there, and a fire started, and there was loss of life, and there was injury. And I thought we could have had a situation similar to that here. Thank the Lord we did not. But now, again, we're being asked to just put some of these safety things aside because we don't want to hurt the business. And it's a difficult decision to make, but we have to err on the side of the safety of our citizens.
Thank you. Mark?
Thank you, Mr. Mayor. I think that I agree a bit both with what Carrie Evans said and what Lisa Olson said. But I'm not at this point willing to vote to put this organization out of business. I think that hopefully the lesson is learned. It appears to me that the owner has some professional advisors that are perhaps providing better direction. So I would be in favor of the stipulated settlement, and then we deal with 2024. But I think that putting this organization out of business is not necessary at this point.
Any other comments? Paul?
Just want to make one point to Mark's comments. The professionals that are in place today guiding the applicant are the same ones that were, Deb Hoffarth who the letter was directed to back on October 3rd, 2016. So I don't know how many of the variables have actually changed, but the behavior has remained the same.
Steve? Go ahead, Steve.
I think it'd be better to finish the dialogue that they're having.
Okay. Lisa,
So
sorry.
I truly just need a clear clarification so that I can vote fully informed. If we approve this motion, this license holder cannot apply for license for 5 years. Am I
Correct.
understanding that the right way? Okay. And in doing that, the sale of liquor in her establishment, that part of her business would go away. So, okay, thank you.
Steve?
Thank you. I think the issue of public safety is the preeminent one here. They were running a business that wasn't safe, that didn't meet the standards, didn't meet the rules that everybody else has to meet. And the purpose of the rules is to protect life and property. That worries me greatly. I also remember, as Lisa does, that there have been numerous issues in terms of building codes, and we've been asked for exceptions and tolerance and lenience over the years. That troubles me. I think there's a pattern of playing fast and loose with the rules. On the other side, I think the rules are arguably vague. The concern I had was echoed by the applicant's attorney herself here. That doesn't excuse not following the rules, and it doesn't excuse scheduling events where you know you shouldn't. But I think that is a consideration here. I'm not so concerned about how many good deeds they've done. I think this is imposing the death penalty on a business and its employees and its customers, and I think that's not a proportional kind of penalty for flagrant violation of rules. In her defense, the attorney says that she relied on the contractor to have fulfilled all the requirements. Remodeling is complex, and I think that weighs a little bit in their favor. You pick someone and they're licensed presumably, and you trust that they follow the rules, and it's complicated, and I don't know the owner ultimately is responsible, but I think you defer some of that to, delegate some of that to the contractor you hire. The role of the attorney, I think, is a little bit more ambiguous here. I mean, obviously, things were ignored and were not given the weight they should have been given. But I think the thing that, so what I'm trying to weigh is the issue of public safety and compliance with the rules, making good faith effort over the years to comply with what the city is saying you really need to be doing, versus the consequence of the offense. It bothers me from a political standpoint that you lose your business because you screwed up. I would feel much more comfortable if there were, in fact, letters of warning and we had closed the business for 3 days and 7 days and 30 days. I think that provides a very clear message that what you're doing is wrong. But after the first formal violation, to put you out of business, I think is not really adequate, especially when there's some lack of clarity about what the rules exactly say. That seems overly harsh. Usually people get formal notices that they've messed up, and I don't know that those have been provided. There certainly have been numerous informal notices that you need to be more careful and you need to obey the rules, and we did shut them down on at least 2 occasions, which is very appropriate, and I appreciate the efforts of our police in doing that. But I think to go from one formal offense on the first offense to having this penalty would be draconian. So I will vote against that. I don't want to get into the next item, but I will, when that comes up, I will ask that additional conditions be imposed on them and additional closure be imposed too. Although New Year's Eve, the proposed settlement was through New Year's Eve, I think that, we have a few more days that we could, and I would recommend we impose on there in terms of them being closed. And I think New Year's Day itself may be a lucrative time for them. So I would like to see a more strict punishment, but I think closing somebody down is too strict given the circumstances. And I don't mean to minimize by any way, in any sense, the public safety issues here. That's not good, and we can't tolerate that. And there's also, I think, another issue too of, over the years, the council has repeatedly been asked to waive building codes and other requirements and permit requirements, and usually it's a contractor or developer coming before us saying they didn't know this, or, could we please give them a break because it's hard to do business or whatever. And I think we have this has gotten better over the past few years, but we have a history, I think, of deferring to people who haven't followed the rules and being asked to make exceptions. So I don't like doing that either. But again, I think to me here, the key issue is that the punishment is not proportional to the offense. So I'll be voting against the motion, but I will be asking for a pretty significant punishment beyond that.
Carrie?
I have a question either for the city attorney or special counsel. In our deliberations for the revocation, whatever, about the under 530, is it appropriate to be considering issues like public safety and there are other issues with building permits and stuff? Is that appropriate factors to consider when making our decision? Or are we bound to just look at the 5 violations before us?
Katie, do you want to take that one, or do you want me to?
You certainly can, if you'd like.
When making your decision, if you're going to deviate from the fifth violation, I would definitely substantiate that with a reason for why you're not doing that. So if the reason is based on the building code, like if it's based upon the evidence before you here today, and it should be based on the evidence that you're hearing here at this hearing, I would state that for the record. That'd be my recommendation.
Steve?
I wanted to clarify too, with either you or the special counsel, the outside counsel, whatever. In terms of the penalties that are specified in the ordinance in section 5-32, are those mandatory penalties, or are they simply suggestions or options that we can impose? Because we've talked about this being the fifth offense, and it says business liquor license recommended to be revoked. It doesn't say it has to be revoked.
It seems like the first four are mandatory and the fifth is recommended.
Could we get an official opinion, not a
Yeah.
learned opinion?
Katie, do you want to respond to that one?
Sure, yep, no, it's discretionary, since it's just a recommendation. The council has it within their discretion to decide what the penalty should be.
That's for the fifth one, but not for the first four.
But the language is, the licensee is subject to the following penalties, and there is no, in first through four violations, there is no recommended language. It says the licensee is subject to the following penalties.
Right, I think it comes down to what you find to be violations in the instance.
What does that
And then
mean?
you're just, well, so if you, we've presented, 5 potential violations here. If you find those, then it's discretionary under here, because then you just have a recommendation. If the council finds, nope, there are only 3 of them, then you're directed to do the 7 consecutive days. So I think it's up to you in the terms of how many violations you find, and then what that penalty is for that many violations.
So, okay, so my motion probably needs to be qualified, right? To.
Well, we have a motion
Oh,
and
that
a
mo-
second.
oh, right.
We do have a motion and a second on the floor that
Right, okay.
we're currently discussing.
We're all over the place, I'm sorry. Okay,
I'm trying.
no, you're doing good, you're keeping us in line.
Paul?
And just to clarify, or maybe a question for staff, obviously, there's been applications for the second floor special use permit. Has the applicant ever applied for a special use permit? Have they ever gone through that process for special use permits in the past?
Special use permits in general, or special use permits for the second floor?
In general?
Yes, I believe I have issued several special permits for Ms. McLaughlin, either off property or up front. I believe we've probably said no to 2 by her putting the second floor as the premise.
But the applicant is aware of the process and has gone and is familiar with the process?
Correct. I've sat with her multiple times in my office and done the application with her.
Okay, thank you.
Anything else? We do have a motion, just listening to it, and I can go either way on it. But I think my concerns are, we have somebody who has admitted to 5 alcohol violations. And when it comes to building code, they've known about it for 7 years. They've had, you can arguably say they've had a premise, or not a premise, they've had a location on the second floor that's been unsafe for 7 years. We've been dealing with its staff, and the amount of staff time that's been invested in this is incredible. And we also have to look at what kind of a precedent we're sending to the future. I think if we can use military terms, we got to do some strategic deterrence as well. We want to make sure that this doesn't happen again, whether or not. So I think I'm going to vote for it. That's where I stand. Any other debate? Any other questions or comments? If not, we have a motion for revocation and a second. Please call the roll.
Pittner?
No.
Quadrigula?
No.
Ross?
Yes.
Burlingame,
No.
Evans,
No.
Janser,
No.
Olson.
Okay.
Motion fails.
Paul?
Mr. Mayor, I'll make a motion to implement the staff recommendation from our previous meeting through the end of the year. Suspension of the license through the rest of the year.
I'll second that.
We have a motion and a second to suspend to the end of the year. Discussion, Paul?
Thank you, Mr. Mayor. Again, I think this is an appropriate first step in this process. I appreciate the candor and the conversation we had. Obviously, we are going to be picking this up as a committee in the near future, looking into these ordinances, and I think there's been a lot of good questions that have been raised on clarification items. You know, what standard do we want to hold license holders to? Whether it's through safety codes, violations, if this would have been the fifth violation independently, would we have felt differently on revoking the license? I think all healthy conversation. I think it's a conversation that has to have been had. I think it'll provide direction for the committee that's going to convene, and I think we can make a lot of good improvements. So again, I'll vote to support this suspension through the rest of the year.
Any other comments? Carrie?
City Attorney. So because the motion is veering from the code, what is, we have to put on the record, right, why we're doing that? Because we're not, I think that's what special counsel said, correct?
Yes, I would make sure that you enunciate your reasons for suspending it for as long as you do.
Do that in the motion or just in our discussion?
I think you can do it in your discussion. We're going to have an order for you to sign afterward that we'll prepare. And so we'll list those things that are your reasonings why.
Mr. Mayor,
Go ahead, Paul.
I guess just to justify, that's the rest of the meat that's left on the bone. To what Chief Klug, that's what we have to work with. That's the extent of the penalty we can have outside of revocation. So I guess we'll deal with what we have left of this license in this calendar year and deal with the next agenda item after this.
Sorry.
Carrie?
My reasons for supporting the motion are, as I said before, this is the first time this establishment has come before us with a violation, and I do not believe, as Steve said, that there was this huge nefarious plan. So I'm okay. We're basically taking away the rest of the 2023 license from them and dealing with their 2024 license on another agenda item. But I think it is commensurate with an establishment who is before us for the first time.
Any other discussion? So, Paul?
I just want to, again, I agree they're before us for the first time, but I want to be very clear, and I don't want to dilute the work that staff has done. This came up, and then with a little bit of digging, with literally chatter around City Hall, several infractions were discovered. So this is minimal work done by staff as far as digging into the background, but numerous hours of trying to help an applicant and a business owner be in compliance, dating back to 2016. So this is not brand new information to the applicant, and honestly, if I were them, this is a Christmas miracle. So.
Any further discussion? If not, please call the roll.
Pittner, Padragula, Ross,
Yes.
Burlingame,
Yes.
Evans,
Yes.
Janser,
Yes.
Olson.
Yes.
Motion carries. Moving on to item number 5 on the agenda. That's the alcoholic beverage license renewal for KP2 Inc., doing business as The Spot. What are the wishes of the council?
I wanted to
Go ahead, Steve.
ask our attorney, can we make the renewal effective as of a date beyond January 1st? Because I noticed in the stipulation, they were going to be closed for from the 18th, I think, through the 31st, which is, 12, 13 days. Given our suspension for the rest of the year, today's the 22nd, they would be closed for only 9 days. Can we,
She's been closed since Monday, though.
I'm sorry, has she been closed since Monday?
Not via direction from the council. She did it on her own.
We,
We're wrong, the spot has been closed since Monday just as an act of good faith, is my understanding.
oh, that's nice.
Yep.
Okay, so that Monday was what day of the month?
18th.
18th.
So she acted like the stipulated settlement was in place, you know what I
She
mean?
did, okay.
She went with the 18th through 31st.
Okay.
Despite that not being ordered by the council or staff or anybody else, she's complied with that settlement as though it was passed.
So there has been a punishment.
Just as an act of good faith. She did that on her own accord. Nobody at the city or in the city council didn't take action on that.
Okay. Would we still have the authority to renew the license of it as of beyond the 1st of January? If we wanted to?
Oh, you mean if we didn't do it now?
Right. Could we renew it as of January 2nd, for example, or February 2nd?
I believe that you could. I would articulate your reasons for doing that, though. Katie, correct me if you think I'm wrong.
No, I think that that's allowable.
Okay.
So like issue the 2024, but like make the effective date? like,
Right, January
another
2nd,
date.
exactly.
Okay.
The other question I had is, I realize and appreciate all the efforts staff have put into this. Part of me wonders if we could just be done with this and not have them have to come back all the time. What I'm wondering, and I guess I just wanted input from staff, was could we make the issuance of the license contingent upon them getting the certificate of occupancy for the second floor and having the whole business compliant? Is that something that is likely to happen, or would it take a long time, or what? Because I hate to see us having to come back there all the time, and they're having this back and forth. I mean, at some point, we should be done with this, and I'm wondering if maybe we could make the license renewal contingent upon them getting the certificate of occupancy for the whole building, for the whole second floor.
Go ahead, Harold.
I'll weigh on that one a little bit. There's some complications with regards to that. So first and foremost, once you register that premise and license that premise, so let's say the first floor, there are certain restrictions that come with that, such as age restrictions, right? You can't have events in there where you have families and kids. The challenge with what the spot is trying to do, and I think it's a needed concept within our community, is a safe place for like weddings and family events where alcohol can be served, but people underneath the legal age limit can actually be in there. So I think there is reasoning and justification for why only the first floor would be premised, and the second floor is only allowed to do those events underneath the circumstances of a special event permit. And so in answering your question, yes, you could do that, but in effect, what you would be doing is you would not be allowing them to sell alcohol on the first floor where it's maybe a full legitimate bar, right, until they're trying to finish out the event center. So it's difficult to separate those two aspects of the business. Now, I will say from a staff perspective, I do believe that whatever we can do to enforce the necessity for going through the proper permitting process, the inspections, and pulling the certificate of occupancy for the second floor, that should definitely be a focus and a priority. But I would, again, the complication comes in of not approving the liquor license, which, if properly done on the first floor, which does have a certificate of occupancy and can work, and in a more restrictive manner, it would be, I don't know that we would want, as you discussed here previously, you don't want to shut down the business, right, completely. And in fact, by not doing that, they wouldn't be able to sell alcohol on the first floor either.
And you're comfortable, and I appreciate that clarification, that's why I asked for your guidance and staff's guidance. You don't see the staff having to spend a lot of time in the future monitoring? I mean, we're obviously not going to give special use permits for the second floor. You're not concerned the police would have to be checking to make sure it's not being used?
I do believe that given the history and the experience we've had recently, we'll probably be keeping an eye on it for a little while. But again, events shouldn't happen in the second floor until those safety issues are resolved. And ultimately what staff wants is we want compliance.
Right.
For the safety reasons, right? Okay. So our ideal situation is that the property owner submits their permit application to the city, and we're able to review those and make sure that those fixes and changes are in accordance with what the code states. And then we're able to come and inspect and make sure that those are built in according to the specifications in the pulling the permit. And then once approved, we can issue a certificate of occupancy. And then at that point, the second floor, every time they want to have an event up there, they want to serve alcohol, they would have to go through the process with the city to pull a special event permit.
Okay, thank you. That helps.
Kayla?
Just to clarify one thing too, there was a point in time when staff, AKA the fire department, had gone over there and it's boarded and locked. The second floor cannot be accessed unless the fire department unlocks it. I believe Chief Kelly said yesterday in a meeting that we were in that if work needs to be done, they are welcome to call the fire department. They will come unlock it, but they will be locking it up in the evenings until at least the health and safety violations have been attended to.
Thank you.
So, Paul, before, I just want to throw this out, kind of piggybacking on what you were talking about, Steve, and that is, we have 5 violations, so we can go up to revocation, right? And we already dealt with that, but we're falling somewhere between 18 days and 5 years. And I think we've got the 5 violations, so I believe, my opinion, I mean, I would support a motion to hold their license until they receive that certificate of occupancy. When they receive that certificate of occupancy, because I still feel that there has to be more than just an 18-day suspension. We need to send a message to other businesses, and we need to send a message that we've been dealing with this for 7 years. Public safety issues for 7 years. Now, if they get it done in 30 days and they get a certificate of occupancy in 30 days, then they're going to have their license by the end of January or February 1st. But that's something that I would support. Paul?
Thank you, Mayor. Here's a question. So with the action that we took on the previous item, their business is closed, not just the alcohol sales, their business is closed. Am I correct?
That's correct. They wouldn't be able to sell alcohol anywhere in the building,
Okay.
including the first floor, through the end of the year, which they have already closed and are not doing.
But they couldn't even be open. They couldn't be open as a billiards hall?
That's correct.
Okay. So if we were to deny their license renewal until, let's just say, May 1st, right? I'm not saying that, May 1st, could they be open as a billiards hall, just not selling alcohol until that date?
Katie, feel free to weigh in here, but you have to have a state license as well. And so the state license is exactly like the city license where you have to delineate a premises and you can't turn the premises on and off. So even if the city were to go down that route, they would be out of compliance with the state license with the allowing minors in if that's how they were going to operate the business.
And even if they didn't let minors in, if they had, and again, I'm not looking to torpedo a business, but if they had a pool league that wanted to meet throughout January, but alcohol sales were not allowed because they didn't have a license and everyone was of age, which anyone participating in a pool league there now is of age, would that be a permissible use? Would they still be allowed to have those and serve juice and water and soda?
And Katie, feel free to weigh in here if you want. So I guess, as I view that, and Deb, if you want to make any statements on that as well, feel free to weigh in. But if you have the state license delineating that as a place where they can serve alcohol, and if you don't have the local license, that's a condition of the state license. So if you don't have a city license for there, that's a condition of having your state liquor license.
Chief?
Mr. Mayor and Alderman Pittner, yeah, just to clarify that, they could, as long as the council was okay with it, they could operate as a billiards hall without selling alcohol, but they could not allow minors because they can't turn that premises on and off. So they would have to still maintain the same rules if they're operating under any kind of license, whether it's state or city.
Okay. Follow up to that. So can they have a state license without having a city license, or is the state contingent upon them receiving a city, or vice versa? Michaela.
I can
Kayla?
I can answer that one. So when you initially apply for the state, they require to see the city license prior to issuing. With renewals, the question on the application is, do you hold a city license? And more often than not, they'll say yes, because they technically during renewal time, they should have a 2023 or the year that they're applying for the next, So I have found out that the state will issue license for the next year without us showing proof of a license, but they're not allowed to operate without a city and a state license,
Selling alcohol.
selling alcohol.
I have a question
Gary.
for Deb. Has the state 2024 license been approved for this establishment?
No, I don't believe the state has been issued. It would be contingent upon receiving the 2024 license from the city of Minot. It has been applied for, but it would not, I understand it would not be effective until there's verification from the city.
But you
Correct?
just said the state will renew
You
without
could,
verification.
she technically could be getting an email at any point in time. If anyone turns in late, my high recommendation is for them to turn in a state application for them to start processing. Taco Felice, this is kind of how I found out, was Taco Felice called me and said they already had their license, but they were still getting City of Minot invoices. And I said, okay, my office didn't send out a license because we don't have your application. And she goes, well, the Attorney General's did. I said, that's your state license. So then I called the state because I was under the impression you had to show proof of the next year's license. And that's when they clarified on the renewal, it says, do you have a current city license?
But at the time of application, you do.
At the
So
time of application,
I'm
you do
assuming
have
on
a
the current application for KP2, it says the checkbox for yes, we have a current license has been checked yes.
I don't. I think she said that she wrote pending, and so she does not have a state license as of right now.
Okay,
No, she's not
okay.
received it.
So can somebody, let's say she gets a state license and it starts January 1st and we put something on, right? Like what's May 1st. Would the person be legally able to serve alcohol with that state license within the confines of Minot?
No.
Okay.
And that's my understanding as well. Like, without the city license, she cannot serve alcohol even under the state license.
Paul?
Mr. Mayor, I'll make a motion to renew the license effective date of January 18th of 2024. That way it'll be a 30-day violation. It'll be a 30-day, and I'll look for a second.
Second.
I'll second.
Oh, go ahead. You
We have a
can,
motion by Paul, second by
Steve can have it.
Steve. Paul.
Again, I agree that a precedent is semi being set here. Granted, it's a little bit of a different, having 5 violations come at once, but again, of all the variables that we've discussed have brought us to this point. And it's my understanding that the establishment will still be able to operate its other functions. Even if they maintain a state license, if everyone's over the age of 21, and anyone can correct me if I'm wrong, people can still enter the establishment. They are just not allowed to have alcohol sales on premise for that time.
Maybe Chief Klug can, I think this was a question among staff on whether it should be full business closure or not. And I don't know how he would recommend it in order to ensure that alcohol wasn't being sold since they are a cash establishment.
Mr. Mayor, Alderman Pittner, I think under the suspension, no, they can't be open. Under the unlicensed portion, I don't think the same rule applies. They're just not licensed to sell alcohol, so I think they could be open as a business if that's what you chose to let them do. As long as it wasn't a stipulation of the license that they also be closed. I think that answers the question, but
No, I think it does, and again, it's going to come down to the business owner. Is it profitable for you to open a billiards hall without alcohol? If it's not, and if your staff costs overrun your profit, you're losing money having people in the building, maintaining the building. And also, you'd hate to have an infraction as an unlicensed premises in the city of Minot without a license, because also another very serious violation. Granted, I think it would probably allocate some resources of staff to make sure maintaining compliance, and the temptation is there. I don't know if that juice is worth the squeeze for the applicant or not, but again, I'll leave it out there for discussion.
Mr. Mayor?
Lisa?
I would amend the motion because I'm in favor of where you're going. However, I don't want the alcohol to be given away for free either, to entice people to come in. So my amendment to that motion would be that there would be no alcohol in the building, that the bar stock would have to be locked away.
I'm fine with that.
Is the second?
Yes.
Second's fine with that. Okay. We'll add that to the original motion.
There's no objection to adding that to the original motion from any of the members? Okay. I do have a question of clarification while I have the mic, if the council will allow. So under our ordinance, typically the renewals begin at 12 a.m. On the renewal date, which is typically January 1st, 2020, well, whatever, of the renewal year. I'm assuming that would apply to this motion too, is that the renewal license would become effective at 12 a.m. on January 18th, 2024. Is that accurate?
I would specify 2 a.m.
2 a.m.
so we don't have a power hour scenario.
So renewal.
On January 19th, then it would be.
January 19th, excuse me.
Yeah, okay.
Okay,
Must be closed through January 19th, 2 a.m.
okay.
No, 18th through, no, 19th. Yeah, you're, okay.
So just to clarify, the renewal is not effective January 1st. The term of the license will commence at 2 a.m. on January 19th,
Correct.
correct? Okay, so there will be no license, just as a point of clarification, from January 1st until January 19th at 2 a.m. That's how I'm understanding the motion, just
Correct.
as a point of clarification. Okay.
Mr. Mayor?
Yes, Lisa?
And I think with all of this does not address the second floor. She needs to still do whatever is necessary to make the second floor usable. So all we're doing is taking action on the premises, correct?
Yeah, I believe that the second floor will still be chained, padlocked, will be blocked.
Right. And so
for use.
if that needs to come back, either to us or to the building official or however that is, that will be separate action.
And the second floor on the diagram for the 2024 is not on. Like, it's the diagram for the 2024 application it wasn't the one she showed us, but it was those same spots. So it's not the second floor, so.
I can pull that up as well.
Even if it got up to spec and stuff, she still couldn't serve alcohol up there because that's not what her liquor license
At
covers.
the premises. to
Not for
which it relates.
2024, at least.
She would have to special event it. If she gets her certificate of
Yeah, for
occupancy.
special events,
yeah,
you need, but
she'd
yeah.
have to special event it.
But like, she can't open up like a cash bar up there.
Yeah.
Yeah, there's the spot that we're licensing. at the
Mark.
spot.
A question for maybe Michaela or somebody. So just following along that thought process, is there a process for a liquor license holder to amend their license application so that if in fact a build-out happens and the necessary codes are met, that the second floor in this case could be added to that 2024 license down the road?
You can amend your application at any point in time. It normally just requires a new drawing of the premise that the owner would like to add. I believe Chief Klug and Lieutenant Chapman usually go on a walkthrough of the extra space to make sure that it's allowable. I believe we've done it with many places, so, and then he'll sign an approval and it will become their new premise.
Mayor, if I may continue.
Mark, you still have it.
I appreciate that, and the reason I'm asking for clarification on that, and that's the answer that I expected, is that given the history of what's happened with this business, I certainly wouldn't want the owner to assume that, okay, we get the codes met and now we're automatically licensed for the second floor. I mean, that's the kind of confusion that, is would be most unfortunate, especially in this case.
Paul?
Just to respond to that real quick, again, citing the letter from 2016, it's clearly outlined from City Attorney Hendershot that this is only applicable to your licensed premise on the main floor, not with the basement or the second floor in question. So I think that's been well documented throughout the history of this. So hopefully there's no confusion on that. And a follow-up, would it be a permissible use to bring alcohol onto the establishment under this? Would it be a BYOB? Because we don't want that happening either.
Chief Klug, I believe state law does not allow that.
Correct. If it's a premises, it could not have BYOB either. So only alcohol from that.
But it'll be an unlicensed premises.
But it will be licensed with the state, being that she has her application in.
Well, if she opens up the pool hall
during
and
the-
having people bring in their own alcohol she provides the mix and they bring their own alcohol in, that's what we want to prevent, and it sounds like through the state that it's,
Correct. If this application's already been submitted, I would guess, like Michaela said, she's going to receive an email any day saying that that license has been approved. If either license is in effect, you can't bring alcohol onto their premises.
okay. Does that, go ahead.
It does, however, I would hate for someone to circumvent the process and, pull their state application and say, I'm not a licensed premises. And if that's a possibility, I would like to clarify that in my motion, I guess.
And Mr. Mayor, Alderman Pittner, I guess the one thing I would add to that too is when this decision is made, we have to notify the state of the action that was taken against her license. That doesn't mean that the state can't take an equal action. So if they decide that she's not licensed and we decide she's not licensed, there's not a license in play. And at that time, there'd be nothing to prohibit her from having a BYOB at that point. As long as there wasn't any kind of sale attached to that. So it's a little confusing.
No, it makes a lot of sense, so.
I'm still confused.
Harry?
And maybe the owner's intent is this, but are the doors of the establishment going to be closed till January 19th at 2 a.m.? Like, you know what I mean? Because this is just saying, right, like, we can't say she has to close the doors, can we? We can say.
We're trying to prevent that.
Right. So all this is saying is through January 19th, this company cannot sell alcohol in its licensed premises.
She will not have a license.
Well, she'll not, in her
Yep.
unlicensed, well, yeah.
She'll be unlicensed until
Right.
2 a.m. January 19th.
But the doors of the establishment can be open.
Yes.
Okay. So I revoke my question, Deb. I don't have, yeah, okay. Oh, okay. I think
Any further debate? Steve?
Just a comment. I'm not really keen on punishing people, but I think the history of the establishment is problematic. And for me, the primary issue is safety. I mean, at one point, there were over 200 people in a place with only one exit. It was dark. Most of them probably were drinking. Their judgment probably was impaired if something had happened. I don't know that we can count on them getting themselves out of that second floor, especially if we're dark, safely. And that really worries me. I think what Lisa mentioned is kind of the nightmare scenario if there being a catastrophe. And that's the reason I think that some consequence, some punishment, if you will, is necessary. The establishment jeopardized the lives, the safety of several hundred people on at least one occasion, and that's not something I feel comfortable allowing and just letting happen. So I think there has to be a consequence for that, and people have to get the message that you have to keep the public safe, you have to keep your patrons safe, especially if they're in a vulnerable kind of state. It's kind of like if we're talking about a nursing home or even a hotel where people aren't used to the circumstances, the environment, and their ability to take care of themselves is limited. I think that would be something we want to be very cautious about as a community. We need to protect innocent people, innocent lives.
Thank you, Steve. Any further comments, questions? We have a motion and a second on the floor.
Can you just repeat the motion one more time, Michaela? Just so-
Yes, this will probably help for me as well. The term of the license for the 2024 spot will be January 19th at 2 a.m. 2024 through December 31st of 2024. If open as a billiards hall, all alcohol must be removed from building.
Does that sound right, Paul?
Works.
Okay. All right, there's a motion and a second. If there's nothing further, please call the roll.
Pittner,
Yes.
Padragula,
Yes.
Ross,
Yes.
Burlingame,
Yes.
Evans, Janser,
Yes.
Olson.
Yes.
Motion passes.
Moving on to item number 6 on the agenda, and that's adjournment.
So moved.
We have a motion. Is there a second?
Second.
All in favor, say aye.
Aye.
Merry Christmas. We are adjourned.
Thank you. Same to you.